Okay, today's topic returns to lecturing that I was doing earlier in the semester when I was lecturing about the histories of family, women. I talked about the Married Women's Property Acts, talked about changes in the nature of marriage, talked about a set of issues there, but I didn't get to issues about fertility, adoption, limitations on fertility, including abortion. I didn't get to that. I'm going to talk about that today, and then really quickly I'm going to hustle through a kind of timeline of 20th century sort of women's movement, I guess is what I'd say, or sort of highlights of law and women not adequate, I will say in advance. And that's the nature of being pressed at the end of the semester in the Zoom School of Law. Okay, so let's go back. Now that we've not broken our promises and we've married either with or without a minister, then one of the circumstances that may arise is the presence of children. And with some of the material about fornicating servants in the 17th century, we all discussed a little bit about how that's going to come out. One nice, although, well, we'll get into something in a sec. One nice factoid to know and share with your friends when you're hanging out with them doing happy hour on Zoom is the fertility rate through the 19th century. And this is going to be for white women. In each decade of the 19th century, white female fertility declines. It starts at 3 per woman, 4 children per woman, 5, 6, 7.04 children per woman, and drops to 3.56 children by 1900. So 7.0 children per woman drops to 3.56 children by 1900. Remember when we did a little survey in class about how many of you had siblings and how many? That 50% reduction in the number of children is, I think, the most important detail regarding the history of women and family in the 19th century. With half as many children, we've got to ask, what happened? How did this great reduction in childbearing come about? So, there's no clear answer. There are limitations on fertility. Part of the story is that women were successful in exercising greater control over their bodies. They prevented pregnancy with later marriage, with abstinence, by prolonging breastfeeding. Don't rely on that as a technique. Through coitus interruptus, really don't rely on that as a technique. And through other methods of birth control. Husbands must have participated in the limitations on family size willingly as well, as together the couple might consider the high cost of raising children. Linked to this are things like shifts from agricultural to industrial life. When you live on a farm, you want lots of hands to work the crop. One way to get those hands is to have more babies. Another is that with shifts in the nature of the family, individual children became increasingly important and deserving of more time and attention, which limited the number of children that families had. And that's a longer term process that I can just touch on. And I don't want to say that children were unimportant in the 17th century, but in the 17th century, if you're living in the Chesapeake, their pre-modern times is what they're described as. The families were less child-centered. No one would understand apps in which you keep track of your ovulation so that you can conceive at the right time, and no one would understand all the efforts we take driving our kids around to sports and all that kind of stuff. No one would get any of that. It'd be just too much. But with a quarter of the children dying by the age of 1, there's kind of less focus on them. I mean, they would reuse names. I think that's a really good indicator that a child would be born, they'd name the kid, that kid would die, and then another kid would come along and they would name the kid the same name. Perfectly good name. Why not use it again? That strikes us as kind of horrible today. But it's a measure of a shift today that we are more child-centered in what we do than they were at that time. Here is where your legal history professor gives you a quick little history of menstruation. It's more fun in class. But the thing to know is this, that people in the 18th century, there were plenty of people, including women, and into the 19th century, confused about when conception was most likely. And one of the measures of that confusion was there was a fairly widespread belief that the least likely time that a woman is going to become pregnant is 2 weeks after her period starts. No, that there was this thought that when she's menstruating, that's when she's going to become pregnant. Notice how that theory doesn't work out, right? But the question is this: if that's what you believe, if you believe that if a woman believes that you're least fertile 2 weeks after your period starts, which is exactly wrong, then how many pregnancies does it take before you figure out that the theory is faulty, right? If you're keeping really careful track of every time you have sex, then maybe you can do it. If you're having, lots of sex, then who knows? There's a really terrific book by Laura Thatcher Ulrich, Ulrich, called The Midwife's Diary. I'm confusing it now with The Handmaid's Tale. I think it's called The Midwife's Diary. It's got midwife in it. And she found diaries where people would keep track of when they had sex and then when they got pregnant, and these little X's in the things, just that kind of prurient stuff that historians love. But I would contend that it wouldn't be the first time that a woman gets pregnant that she'd say, oh, that theory's no good. It would take like 2 or 3 babies before you figure it out. Notice, too, that the story I told about the shift to more industrial work in New England, say, where women for the first time are going to factories, young women are going to factories, that's where they can begin to share some of this information about themselves, their health, their outlook, their bodies, sex, that sort of thing, sort of early consciousness raising. But until then, who knows? I mean, recall back in the 17th century where we have this person of ambiguous genitalia in the Chesapeake, and it takes these searchers go in, they send the women in to search him, they send the men in, and then the guy says something and they say the aforesaid searchers stood unresolved. So people don't have a clear sense of how all this stuff works, is the point I'm trying to make here with your brief little history on the of menstruation from your legal history professor here. Okay, so there are limits and sets and development of new methods of birth control, and I'll come back to that because that creates all sorts of problems in the early 20th century with people complaining that it's obscene and blah blah, and the passage of the Comstock Law and Margaret Sanger's efforts and all that. All of it complicated and problematic. So on the one hand, we have successful efforts to limit conception. That's one of the things that happens. On the other hand, there's also adoption, and I'm going to add to the syllabus, and I don't have it right in front of me now, an 1851 Massachusetts statute that passes the first general adoption statute. Before this, what you have is it's much like the pattern with regard to forming a corporation. There are lots of private acts, special acts of state legislatures putting people into new families. A lot of these name change statutes are really adoption laws made for particular individuals. Lots of them say that thus and such a person has a right to inherit the property from the new parent, right? And the Law and Society, or the instrumentalist explanation for all of this, is that the widespread ownership of land, Friedman would say, generated new problems for the legal system, called forth changes in the laws to adapt to it. If you have no property, it makes no difference what the adoption law is. In some poor countries today, for example, many of the kids may be formally illegitimate. Not that there's no family life. The point is that people have no reason to bother with the legal forms of marriage. The customary forms do just fine. Or another example, people in Turkey took on the state-sanctioned version of Islamic marriage in droves during the Korean War. And the reason was that married Turkish soldiers who served each got a $10,000 life insurance policy, right? But not if they weren't in the formal version of marriage. We can wonder, of course, what the relationship is between these statutes and conceptual issues that I just talked about the changing nature of the family. The laws are simultaneously accomplishing an instrumental goal, but there's a moral point as well, which is a point I made with regard to common law marriage, that on the one hand, it makes the transmission of property clearer within families. On the other hand, it does validate the moral position of the parties as well. Now, abortion is another part of the story here that we're gonna talk about, and let me move something over here. Okay, regarding the reduction of 19th century fertility rates, At common law, abortion is legal until what's called quickening, okay? And quickening is, and part of what I have here actually is a book by Professor Hardaway called Population, Law, and the Environment, and he writes a little bit about the history of abortion here, and he's in the office right next door. So back when we could come into the law school, I talked to him some about this, and I'm here right when the sun's setting and the light's on me. I'm going to stick with the drama because it makes me look a little bit even more like Lemuel Shaw standing in that light in that Pennsylvania studio. So I may just stick with this, and we'll see what happens here, right? So one of the things is that what quickening represents is that period at about 4 to 5 months when people used to think that the fetus began to move, but really what they thought is they called it ensoulment. Ensoulment. It's when the soul enters the fetus. Professor Hardaway writes some about this, and he writes about some of the popes and what the view of the popes were in thinking about this. But the idea was that when the soul entered the fetus, then the fetus began to move, and that was what was called quickening. Thomas Aquinas is the person who calls that quickening, and I'm told I will give you lectures on the history of menstruation, but I don't know what it feels like. But I'm told it feels kind of like a butterfly when you can first feel the fetus moving. Of course, the fetus moves before then. It's just that you can't feel it because there's not enough mass so that you can feel it. And the soul question is one that I'm not going to try to answer for you, right? So the idea, and the woman can feel it somewhere in the 4 to 5 month range is my understanding. I've heard that it feels a little bit like a butterfly. For 2 centuries, abortion had been treated according to the common law rule for at least 2 centuries, which meant there are no limits on pre-quickening abortion, right? That there are no limits on pre-quickening. I'm going to put this light down because maybe that's a little too distracting. There, put the blinds down. That's a little better. And then you can see horizontal lines across me in the film noir in the 40s and in the 30s, 40s and 50s, really. And anytime you see it's prison bars, it means somebody's going to be in trouble. So we're just going to stick with that along the way here. So for quite a long time, abortion was treated according to this common law rule. That no limits on pre-quickening abortion. Post-quickening abortions might be treated as high misdemeanors if the woman died. These post-quickening abortions were not treated as felonies. And here I want to look at something that I learned about from Professor Hardaway, and that's a case from 1812 in Massachusetts. And let's see, I'm going to view this with one page up, one page, and let's make this larger if I can. Let's zoom to, I'm sorry about this, but that's what we are growing to expect. There we go. Okay, so this is a case from Massachusetts, quick little case in 1812 from Massachusetts, the Commonwealth against Isaiah Bangs. And it's an indictment for administering a potion, so it's an abortifacient. It's some kind of potion that induces abortion or induces miscarriage, you might say, either way, to procure an abortion. And it says an indictment for administering a potion with intent to procure an abortion must contain an allegation that an abortion ensued and that the woman was quick with child. So that's what this case is, that it has to say that that we've passed the point where she can begin to feel the child moving, meaning a soul has entered the child, right? Or just meaning that it's gone along far enough. And this happens back in 1810 in Massachusetts. So the defendant's indicted for assaulting and beating one Lucy Holman, and administering to her, so there's domestic violence involved, and administering to her a certain dangerous and deleterious draft or potion against her will, right? So she's pregnant, he doesn't want her to be. We don't know all the details, we can imagine them. To to procure the abortion and premature birth of a bastard child of which she was then pregnant. It could be we don't know all the details. That's enough to say there. The defendant was the father of this, right? And all of this, all this bad stuff happens here. And then he says, no prosecution as the assault and battery charged in the indictment. Verdicts found that the defendant's guilty of the several matter charged, except that the potion was taken by the woman voluntarily. After it's returned, they say to no judgment because there's no indictable offense, right? And then here are the lawyers who appear. And the court says, it's just a simple little thing, says there can be no sentence on this verdict. The assault and the battery are out of the case, and no abortion is alleged to have followed the taking of the potion. If it had been alleged and proved to have ensued, the averment a woman was quick with child has to be included. So that if it's early enough in the pregnancy, they say that there can't be this prosecution of this in this particular instance is what the court decides here. So much more complicated story to there and upsetting in its own view, but an illustration of how the quickening rule worked here. In the 1830s, and I should just step back here and say that with Roe against Wade, I think there's a presumption by many people that abortion had been illegal forever. From before Roe against Wade, it had been illegal forever, right? And that's simply not the case. So it's important to know that here in the 19th century and well into the 19th century, abortion is not illegal, and not illegal up to at all to a certain point in time. And then even after that, illegal only really if there's harm to the woman, though that changes and starts to change in a way that we'll talk about now. So that's one point I'm making. In the 1830s and the 1840s, there are increasing efforts to regulate who could perform abortions and to punish, to identify as unlawful and punish those unlawful abortionists. The American Medical Association is founded in 1847, and an end to abortion is one of its chief goals. Part of that, too, is to make it so that the people who are the allopathic doctors who are part of the AMA are the only ones who can do abortion. So they're trying to push out competitors as well. This is all a way for the profession to enhance its influence as part of the scheme here. In a few states, the restrictions come in the form of tighter laws against the use of abortifacients, these drugs or potions that could induce abortion. And if you look at magazines from the time, you'll see advertisements in the back using coded language for potions that could induce abortions. New York in 1829 makes it illegal for anyone to attempt an abortion except to save the woman's life. By 1860, 13 of the 31 states, there were 31 states in 1860, still had no criminal law at all regarding abortion, and those that did have any laws at all relied mostly on the quickening rule. Between 1840 and 1860, abortion restrictions were challenged in 9 state courts. 7 upheld the common law rule and said that pre-quickening abortion was not a criminal offense. So again, I'm making the point that, abortion was not a criminal offense. It was not illegal in the 19th century, contrary, I think, to what a lot of people believe. Prosecutions for abortion are different, and we see a little bit of that in this Massachusetts case. It's maybe not the best example. Juries treated the pre-quickening distinction as very important. 1840, Massachusetts passes its first separate abortion statute. Between 1849 and 1858, there are 32 trials concerning abortion in Massachusetts with no convictions, right? So people just simply there aren't convictions. In the 1850s and the 1860s, there's a substantial increase in the number of abortions. They increase from 1 in every 25 to 30 live births to 1 in every 5 to 6 births by the 1860s. And then that number of abortions as a fraction of live births goes up. In the 90s, there's 1 abortion for every 2.7 live births. But now I believe it's back to roughly the figure that it was in the 1860s, which is 1 for every 5 to 6 live births. There were in 2016, 186 abortions for every 1,000 live births, and there's a relative low in either 2016 or 2017 of the number of abortions, that it went up after Rogan's Wade, went up for a while, and then it comes back down. And there are a whole set of factors that make it come down. Abortion rates tend to come down when the economy is better, when there's access to birth control. There's also a number of ways that abortions don't get recorded as much anymore. Ones that are done with prescription medicine may not be recorded in the same kind of way as other ones are recorded. But then there's another flip side of it, is that it's harder to get abortions in some places. So that also reduces the number of abortions. So exactly how all that works is a little tricky to sort. The best data, the most reliable data, if you're interested in the issue, are from the Guttmacher Institute, Guttmacher, Guttmacher, Guttmacher. They're regarded as the best data on the number of abortions and trends and what's going on with laws in different states, that kind of thing. The increase or surge in abortions in the 19th century seems to have been concentrated among middle-class white women, which drew some condemnation from religious leaders and also from the American Medical Association. Carol Smith Rosenberg, a historian who wrote about this in the 20th century, examined the efforts of the AMA and concluded that the concern was not with all women and not with poor or single women or seduced servant girls, but rather with strong-minded married women of the new middle class who, in the view of the AMA's doctors, were shirking their natural roles as wives and mothers. Anti-abortion efforts were very much efforts to control the efforts of these women to emancipate themselves and control their own fertility. There's also an effort in the late 19th century, and historians are making this argument too, that to control abortion because it was dangerous for women and it was killing women. That's part of the concern too, and I'm going to tell you some about a historian, other historians whose work I like a lot, who I've been learning a little bit about recently about both of these historians, and one I've lost track of. Here we go. Good. A lot of the remainder of the 19th century story of the regulation of abortion is played out is played out when states began to swing their legal authority against abortion. They abandoned the quickening standards and they used the police power to expand some of that regulation. And by the 1880s, things have shifted, and all the laws have some variant, all the states have some variant of a criminal law on their books. From the 1860s, the 1880s, states passed new waves of abortion restrictions. 1888, 8 states, including California, made the woman criminally liable, but 5 states, including Texas, for example, had no laws whatsoever regarding abortion. There were also 11 states that placed limits on the advertisement of abortion-inducing drugs. So after 1880, there's criminalization. It becomes more difficult to get abortions. Not impossible, but more difficult. And so despite this criminalization, the practice of abortion flourishes. Where it's illegal, the practice has to go underground, which of course makes it more difficult, expensive, and dangerous. And I want to talk about a couple different aspects of that. So in California, for example, abortion becomes kind of generally illegal but available if a woman can go to a doctor and explain why she needs it for a medical reason, or depending on what her relationship is with the doctor, kind of whole sets of reasons from the 1880s forward. But that tightens up and tightens into the 20th century, and becomes and there begin to be criminal prosecutions of people performing abortions. There's a terrific historian named Alicia Gutierrez Romin, whose work I found actually, I took a picture of it when I went to my son's graduation in 2016 from the University of Southern California. I was looking through and seeing what people had written PhD dissertations about, and she was just finishing hers at the time, titled From Back Alley to the Border. And then I just looked her up and found a lecture that she gave on C-SPAN about the history of abortion. And I'm going to call her and talk to her a little bit. So she describes the constriction of the practice in California, and then how you have to have a sort of particular relationship with the doctor and be able to make a good argument. And then it's still a possibility, particularly early in pregnancies, to get an abortion and to get one. So I want to tell. And then during this time period, too, there's another person who writes about this, and this is a woman named Leslie Reagan, Reagan, and she has a book called When Abortion Was a Crime, which is another terrific book on this topic. And her book tracks through what the police do when they find out, and typically they find out that someone has had an abortion because they get an infection or they die. And then it tracks through the various ways that they go, and they try to figure out who the abortionist was, and in particular, they try to figure out who the father was in this relationship. And they do all these kind of dirty tricks, telling the woman that she's going to die and that she needs to speak the truth because she doesn't want to meet God with this kind of truth untold, and they just do a kind of a lot of terrible stuff there to extract confessions from these women as they either are dying or as they say they've been told they're dying. That's part of the horrible story. And then of course the broader horrible story is that in the face of making abortions illegal, women have no other choice but to engage in, they have to find illegal providers of these abortions to go, and that's dangerous, right? That's part of the danger. And so part of the anti-abortion restrictions in the later 19th century, it's not just to keep middle-class white women and make them have babies, but it's also in part because there's a concern for the safety of the women. And here I'll tell you a story. Let's look at here we do it like this. So here's some two pictures I want to show you. And first I want to show you this picture. So that's my grandmother right there. That's Lois Nickel. She's born in 1911. This is my mom right there, Joan Russell. She's born in 1932. So this picture is taken in either 1933 or possibly in 1934. It's unclear. This is their dog Dixie, and you'll notice I'm leaving till last. My grandfather, that's Norman, and nobody likes Norman. Norman's a drinker. Norman's a bad guy. By this time, he's got a girlfriend on the side, and apparently his girlfriend on the side, my mom's middle name is the name of his girlfriend on the side, right? Maybe you can see some of this from how they're sitting. This is taken in San Jose around this time, right? So here's a picture, and my mom has a little brother who's born the next year. I'm not sure whether my grandmother is pregnant at this time yet. And then here's a better picture of Lois. This is the picture we all like of Lois. It's a fabulous picture of her taken, I'm not quite sure when, a sort of flapper style picture. Maybe it's taken in the 20s, I don't know. But that's a picture that I have on my phone of her as well. And maybe you're guessing where we're headed here. She becomes pregnant. Everybody has always assumed Norman was the father. I asked the question, do we know that to be true? I don't know. But after Uncle Dan is born, after my mom's little brother is born, she becomes pregnant again. It's the Depression. People have no money. People are losing jobs. She's got a bad husband who's a drinker. I don't have any evidence that he beats her up, but I know he's a mean guy, and nobody likes him. And my great-grandmother is very unhappy with him. And so my grandmother Lois has an abortion, and she goes where we're not quite sure, and I had a copy of her death certificate, but I cannot find it. It's part of my delay in producing this. I cannot find it, so I have to proceed without it. She has an abortion, and I think she has this abortion maybe 16 maybe 18. It might be as far as 20 weeks into the pregnancy. I'm not quite sure when that happens. She develops a staph infection from that abortion. And whether that abortion was legal or illegal, I cannot say for sure. There's a really interesting thing that happens around this time that Professor Gutierrez Romin talks about. There was a kind of syndicate of people performing illegal abortions headquartered in Los Angeles, but actually performing them very safely, doing vacuum abortions that are using the kind of the latest techniques under the best of circumstances, making some serious money doing it, but doing a very good job doing it, and they're eventually prosecuted for that. And I'm eager to find out some of the names from Professor Gutierrez Romin's forthcoming book when I get another copy of this death certificate, although I'll probably find it right away, because I don't think that my grandmother was fortunate enough to be part of or able to access that illegal yet safe ring. So she instead had an abortion somewhere not clear. She does end up under hospital care for about the last week of her life, but she dies in 1936 at the age of 25. So she leaves, and then my mom ends up living with Norman and his girlfriend for a while, and so did the brother, but eventually Grandma says, no, we're not going to have that, and sends him packing, and then my grandmother raises my mom, and so the story for my mom is that she's essentially orphaned. She's essentially orphaned early in her life. And there's lots of different ways to think about that. Mostly sadness. And it actually, in an interesting way, I'll give you more personal stuff. My grandmother dies from an abortion when she's maybe 4 months pregnant, something like that, maybe a little bit more. So that's kind of along for these days. My daughter's born at 26 weeks. So there's a kind of narrowish gap there between them. My daughter's born at 26 weeks in the second trimester, according to the Roe against Wade description, formally abortable. And I told you, she spent, the semester in Italy, and right now she's back in the United States and in California. So I have, lots of different views about this, I guess. But I would like for the practice to be legal and safe. Is what I would like, and had that been the case then maybe I would have met my grandmother. One of the things that Professor Gutierrez Romin describes is how, as you get further into the 20th century in California, the practice just becomes essentially more prosecution, more and more illegal, and then what you have are trips across the border. So you have the development in Tijuana in particular of abortion clinics that operate there, and then people would go across the border, women would go across the border, have an abortion there, and then come back. In the same way that women in the Republic of Ireland, when I was there, they would take the ferry over to the United Kingdom. They'd go, over to Liverpool, and they were able to get abortions there because they couldn't get them in the Republic of Ireland, although in the north of Ireland, a clinic opens in 2013 during the time that I'm there. Similarly, there's also a movie called Jane, an abortion story, and you can, if you Google that, you can actually get a free link to it that you can watch it through your University of Denver account. You can link to it and watch it, and let me know if you try to find it and I'm not able to find it. And what that describes is a group of women in Chicago in the 1960s who hire a doctor who performs abortions. They're illegal, but there's a kind of word-of-mouth network, and they try to make it as safe as they possibly can. And using this word-of-mouth network, you can get referrals to this network, and then get a referral and get an abortion and have the procedure. And that's kind of how things go. during this period of illegalization as we work toward Roe against Wade. Colorado is one of the early states that makes abortion available. California does in 1969 too, and part of the reason that California says that they're going to do it is they want to stop this practice of women having to go, well, they say it's an equal protection issue, but they don't want to have women having to go across the border to Tijuana to get the procedure, and so they make it legal in the state, and then a few years later in 1973 we have Roe against Wade and the decision against Roe against Wade, and then a set of kind of other litigation and fights over that have continued to the present day. I guess is what I would say there, and I think that's what I want to say. So from Roe backward, know that it's not a world of sort of illegal abortions suddenly becoming legal in 1973. It's a world where abortions are available, abortions are done, they become increasingly used, increasingly medicalized, I guess, maybe is one of the things we say too, and that mostly according to the quickening standard, that certainly before a woman could feel the fetus moving, in this 4 to 5 month period, before that period that there's no restrictions, and then maybe some restrictions afterwards, and that starts to change mid-century and into the latter part of the 19th century, and then really a kind of clampdown on that, a literal clampdown on that in the 20th century, so that for my grandmother during the Great Depression, she has either a legal or an illegal abortion. We don't know. The family thought is that it was illegal. And it probably would have been a more open conversation about it, maybe if it were legal, but I just don't know. There's still, it's something that people barely talk about today, that my mom has talked about only a couple of times, for example. And then as the practice goes underground, the development of alternatives, which include going to Tijuana or creating a service in Chicago that women run, before they can legalize things, before the Supreme Court identifies this right in 1973. Okay, that's what I have to say. That's what I have to say about abortion. Let's talk, and this is going to be a briefish kind of timeline of regarding women in legal history, with an emphasis on a couple of different things. There's plenty to say, there's huge amounts to say, but there's only so much time, and I need to change things up. And actually, if somebody among you is going to be around next year and want to help me with this course the next time I offer it, give me a call. Okay, so we talked about, in the 19th century, we talked about Married Women's Property Act, so we don't need to get into that conversation. But we do want to talk a little bit about when women become involved in lawyering and when women become involved in voting, okay? So in 1868, a woman named Myra Bradwell establishes the Chicago Legal News. It's the foremost legal publishing house and a legal newspaper in, quote, the West, as in everything west of the eastern seaboard. And as early as the second issue, she has a column on the law relating to women, right? Calling for suffrage and reporting on women attorneys even before such women sought formal admission to the bar. So great stuff there, right? 1869, Elizabeth Cady Stanton and Susan B. Anthony, who we met in 1848, found the National Woman Suffrage Association. And then Lucy Stone, somebody named Lucy Stone, forms the American Woman Suffrage Association. 1869, Wyoming grants suffrage to women. So women start voting in 1869, and if you go visit the Wyoming State Capitol, they're quite proud of that. There's a lot of conversation about it. It's important. Early on, they have a woman governor, actually. It happens. The Utah Territory in 1870 grants women the vote. And this is around the time, too, I think it's in 1876, that the United States has the Mormon War, where they send troops out to battle the Mormons, right? Colorado grants women the vote in 1893, and Idaho in 1896 are the next jurisdictions to do it. And no states do more. Well, there's some in between 1910 and 1912. We have a few more states that grant this. 1871, a woman named Belva Lockwood matriculates at the National University Law School. right, after being rejected by a bunch of other law schools. And this law school becomes George Washington University Law School. And my wife is a proud alumna of that school. And she goes to she goes to this law school, and that's a little bit more about her in a bit. Back to Myra Bradwell, right? I mentioned to you Myra Bradwell, publishing the Chicago Legal News. In 1873, in Bradwell against Illinois, the U.S. Supreme Court holds that states may statutorily deny women the right to practice law. In 1872, while that case is pending, they pass a bill drafted by the state passes a bill that provides no person can be excluded from any occupation, profession, or employment because of sex. And this person, Hewlett, who's only 19, becomes Illinois' first woman lawyer. Myra Bradwell's still waiting on the U.S. Supreme Court decision. She doesn't reapply. She's deeply disappointed when the court comes down. She's finally licensed in 1890. Another 17 years later, when the state Supreme Court, on its own motion, reconsiders her 1869 application and grants the license nunc pro tunc. Do you know nunc pro tunc? I didn't learn it until maybe 8-10 years ago. Now for then. So sometimes you have something where you do it now, but you say it reaches back in time to then. It's one of those little magical things that we can do as lawyers. You do it sometimes when you have a judgment that maybe is only granted now, but you need it to have effect, last month or 2 months ago or 2 years ago. Backdates the original effect of it. The United States, then acting on the motion of the United States Attorney General, follows up in 1892, and then Myra Bradwell, who already has cancer, dies 2 years later. Then Belva Ann Lockwood, who we're talking about here, revives the Equal Rights Party in 1884, runs herself as a candidate of that party for president. If you're watching, as I suggested, Mrs. America, about Phyllis Schlafly's opposition to the Equal Rights Amendment in the early 1970s, you'll see Shirley Chisholm, a black woman, as candidate for president in the 1972 election. And I think you should watch that show after you're done binging on the House of Russell here. So she wins 4,000 votes in 6 states. And Indiana actually tries to switch some votes from Grover Cleveland to Lockwood, but they're barred by a technicality. And after this, the party kind of disappears and sort of flags away. Belva Lockwood, though, grudgingly admitted to the Supreme Court bar in 1879, is denied the right to join the State Bar of Virginia. And the United States Supreme Court, relying on the Bradwell decision, reaffirms that state bars may discriminate on the basis of sex. Simply say it'll do it, that they can do that, and they do, okay? Getting into the 20th century, in 1908, you have the Portia Law School, named after the character from Shakespeare's plays, is created for women to attend classes in the evening. And it does so well that a day program is added in 1922. That these evening programs are interesting, and I think I mentioned them when I talked about the legal profession. They give opportunities for working class people, for immigrants, Catholics, Jews. That's the YMCA school. The YMCA runs these evening programs. They allow a different group of people, not just well-heeled men who've gone to the right prep schools and the right colleges and don't need to work, but they allow people who are working to go and to accumulate to get a law degree. They allow that to happen. And the program flourishes, and the Portia Law School becomes the New England School of Law in 1969, right? 1914, I should mention Margaret Sanger, Sanger. She's problematic. She's a birth control advocate. She's also a eugenicist. And I talked briefly, I mentioned during the Progressive era about eugenicism, the scientific belief that you can basically, in figuring out who's got the right genes and who's going to end up smart, who's going to end up with good morals, who's going to end up not being a criminal, all the kind of science of genetics that actually suits Hitler and Nazi Germany especially well, right? Well, Margaret Sanger is a eugenicist. That part of her interest in birth control is to keep the wrong sorts, that's in quotation marks, the wrong sorts from reproducing, right? On the other hand, she's also trying to make birth control more available. She's indicted on obscenity charges for sending birth control information through the mails. She flees the country in 1914, comes back in 1915. 1916, she founds the first U.S. birth control clinic in Brooklyn. And I think it's in the 30s that she ships some diaphragms from Japan back to the United States. And then there's a case that names the calls them pessaries, and names those as the subject of the litigation, because under the Comstock Act, I believe they're grabbed up in the mail and they're held up for that particular reason. So, and that all leads the way to Griswold against Connecticut, which I hope you've read at least a little bit about in 1965, which identifies this right to birth control, right to information about contraception, as a right that is protected by the Constitution, but where it's lodged is a little difficult for us to determine. That, of course, is crucial with regard to the Roe against Wade decision later on. Then finally, 1920, we get the 19th Amendment, guarantees women the right to vote in federal elections. Okay? It reads, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex." Okay, that's 1920 that women get the vote in this country, right? 1923, the first iteration of an Equal Rights Amendment to the U.S. Constitution is introduced. It's drafted by a woman named Alice Paul. Initially, it's an affirmative statement. Men and women shall have equal rights throughout the United States and every place subject to its jurisdiction. The version that Congress passes in 1972, and again, this is what you can look at if you look at the show Mrs. America, is a 1943 revision which says equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Okay, falls 3 states short of ratification in 1982, and I think Virginia just endorsed it, and there's going to be a little showdown about that. But we'll talk more about Mrs. America, but you see not only Phyllis Schlafly, but you see Gloria Steinem, who founds Ms. Magazine, and who was here just a few years ago at the age of 80, just really terrific. Betty Friedan, the author of the Feminine Mystique, is featured in this, as is Bella Abzug, the Democratic member of the House. That there, and Shirley Chisholm, of course, is part of this too. So it's a nice cast. It's a really a good group of, I think it's pretty well done. So I'm recommending it, obviously, to you. 1933, Frances Perkins becomes the first cabinet member in U.S. history. FDR picks her to be the Secretary of Labor. Okay, so there's a milestone there. In 1946, the United States Supreme Court holds that the systematic and intentional exclusion in Ballard, U.S. against Ballard, 1946, B-A-L-L-A-R-D, the systematic and intentional exclusion of women, like the exclusion of a racial group or an economic or social class, deprives the jury system of the broad base it was designed by Congress to have in our democratic society. So, plenty of states, women are simply not permitted on juries, and the United States Supreme Court in 1946 says that that's a no-go. That's what we say there. So skipping forward 2 decades, 1963, the year after my birth, Betty Friedan publishes The Feminine Mystique, and a lot of the Feminine Mystique, it's You could say it describes it's about the dissatisfaction of middle-class white American housewives with the narrow role imposed on them by society. So what I'm talking about here, I am not doing anything close to an adequate intersectional. I'm not doing anything close to an intersectional job. I'm talking about white women's feminism, which has its own sets of problems too, of course. I'm not going to get into all of those. We'll do that at some future iteration if I, well, we aren't going to do it. I'm sorry. 1964, with the Federal Civil Rights Act, creates the EEOC to enforce workplace equality along the way. In 1967, we've talked about Loving against Virginia. 1969, I hadn't realized this. You have the first women in the law courses in the country are taught at NYU Law School in the fall of 1979. Then at Yale, Georgetown's first class is taught in 1970 by Barbara Allen Babcock, my criminal procedure teacher. She left and went to Stanford. She also created the first public defender program in D.C., and I had not realized that, and I'm not quite sure why, but there's a set of these courses that come along in the 1970s, and if you watched any of, I forget which of the nice movies about Justice Ginsburg, you see her teaching one of these courses as well, and she, so these are important kind of incubators for some of the legal thinking that goes into some of this litigation at the time. Title IX passes in 1972, guarantees equal access to academic and athletic resources regardless of gender. Title IX has all sorts of interesting effects. I'll tell you one of them. In my first year class,
I'm not sure.
Alexa's talking to me. In my first year class, a number of women last week received unwanted attention via chats in Zoom. And I am a mandatory Title IX reporter, so that's something that I'm bringing to the attention of the university. I also found a way to stop that, and we're addressing it, but I'm also obliged as a mandatory Title IX reporter to let the university know about that, and that's one of the things that's happening. 1973 then, as we've mentioned, Roe against Wade establishes a nationwide right to abortion with restrictions permissible at later stages of the pregnancy, and there's been lots of fights associated with that, and arguably Casey is maybe even more important than that case right now along the way there. The next year, the first casebook on addressing gender-based or sex-based discrimination is published. Kenneth Davidson is one of the authors, but so is Ruth Bader Ginsburg, and Herma Hill Kay, who when I taught at Berkeley's law school, Bold Hall, it was then called, was the dean at Berkeley while I was there. So that's, I don't know, that was kind of cool for me, I thought. Soon thereafter, Barbara Babcock publishes a book as well on the topic, right? Skipping forward kind of too quickly because I want to get in under an hour. Justice Sandra Day O'Connor in 1981, nominated by conservative Republican President Ronald Reagan, becomes the first woman appointed to the United States Supreme Court. That's while I'm in college. And then in 1992, a year that gets called the Year of the Woman, it's the contentious hearings involving the appointment of Justice Clarence Thomas. I'm now teaching at the University of Texas, where basically no one believed Anita Hill. Current presidential candidate Joe Biden has a big role on the Judiciary Committee there, and I think many things to be ashamed of. And Anita Hill, this professor from the University of Oklahoma at the time, levels charges against Clarence Thomas for a set of sexually discriminatory and predatory practices that she says that he engaged in. It's a real litmus test for kind of what you believe at the time. 93, Justice Ginsburg is nominated by President Clinton to the court. She becomes the second woman appointed to the United States Supreme Court. She has, last year when she was sick, I don't know if you got in on this, or 2 years ago maybe it was, I went downstairs with nearly 100 postcards and had students fill those out, and then I sent those via FedEx. And I have a group, I have some just in store on the shelf. If the need arises again, then we fill out postcards and we send our good wishes to Justice Ginsburg, who, as you know, has had pancreatic cancer, but she can hold a mean plank, is what we say. So that's those are just some of the legal highlights. That's not nearly enough to talk about some of the movement highlights and some of the other things that come along, the organizing that goes into it, the marches, the organizing, the passage of legislation, the shifts within families that happen with plenty of effort and plenty of work still to be done. I might mention, let's see, there was one other thing. Oh, I wanted to mention about Gloria Steinem, too, that Gloria Steinem creates Ms. Magazine, MS period magazine. And there's a funny thing about Ms. Magazine. People don't understand the origin of that. In 1971, you're Miss or you're Mrs., right? And Gloria Steinem makes the point. She first publishes this as like a sample insert to New York Magazine, right? And publishes the first issue in 1972. And the simple point is, you can't tell with Mr. whether somebody's married or not. And that's what Ms. does too. You can't tell whether somebody's married or not because it's none of your damn business. My students, I find now, have no idea that that's what Ms. is for. They think it's simply when you don't know, right? But no, the answer is it's none of your business. So you use Ms. Use Ms. and Mr. It's neutral as regards the marriage question. I'm interested that people don't seem to know that anymore. I had something else that I wanted to mention along here. 76, the first marital rape law in Nebraska. 84, Emily's List is created. That's important politically. Governor Richards, when I'm in Texas, works with Emily's List a good bit, I know. Emily, early money is like yeast, is what that stands for, is establishes a financial network for pro-choice Democratic women for national political office, and the organization makes a significant impact on increasing the number of women elected to Congress. I think I told you I once gave Governor Richards a ride in my pickup truck, and I almost wrote to her daughter, Cecile Richards, was the head of Planned Parenthood, and maybe I'll finish with this, was the head of Planned Parenthood and was a parent at the preschool where my kids went to school. And a few years ago, after she testified and really got battered before Congress when she was testifying, when there were these lies told that they were selling fetal tissue at Planned Parenthood, and they'd sent these people in to take video and then edit it in unfair ways. I didn't write to her, and I should have written to her, because we're roughly the same age. Our kids went to the same preschool. I knew her. I knew her mother. Her mother was close to the same age as my grandmother, and what a different, and a different sort of experience Cecile Richards gets to have, growing up with her mom, watching her mom do just fantastic things and do this great job in Texas politics and be just a spectacularly successful political figure there. And who knows, maybe my grandmother could have lived the same years that Cecile Richards' mother was able to. That's all I have to say. We're coming in at under an hour. Next topic up is going to be maybe a little shorter, but also super interesting. The next thing I'm going to talk about is gay rights, kind of the issue of being gay, the legal history of being gay from about the mid-20th century forward in this country. That's going to be the next topic. Okay, thanks, and Russell out.